Honorable Justice Sanjeev Sasdeval, my esteemed brother, sister judges, Shri Rajiv Virmani, Senior Advocate, Supreme Court of India, Delhi. Welcome you, sir. You will get fresh air in Jabalpur. You are coming from Delhi. Shri Alok Awasthi, Principal District and Session Judge, Jabalpur. Shri Ratnesh Chandra Singh Viseen, Member Secretary, MP State Legal Services Authority. Shri Krishnamurthy Mishra, Director, Madhya Pradesh State Judicial Academy and the Officer of MP Judicial Academy. Shri Vaibhav Mandlavi, Principal Registrar Vigilance. Additional Advocate General Shri Pushpendra Yadav, Shri Rupra, Shri R.K. Singh Saini, Vice Chairman, State Bar Council, Shri D.K. Jain, President, MP, High Court Bar Association, Shri Sanjay Agarwal, Secretary, High Court Advocate Bar Association, Shri Adit Adhikari, General Secretary, Senior Advocates Council, Jabalpur. Senior Advocate, Panel Lawyer, Member of District Judiciary, ladies and gentlemen. As you are aware that we are assembled here, this symposium to listen Shri Virmani on this subject, Art of Cross-Examination. I am presiding division bench criminal matter since last 4 years, and what I found that it's a dying art. Conviction sometimes, most of the time I found that the conviction of accused only because of defective cross-examination. The prosecution has not proved the case, but in cross-examination, questions were asked and the conviction is there. In cross-examination, leading questions are not permissible, but in examination in chief or in cross-examination, it is permissible. You can cross-examine, range is very wide. But cross-examination may either be constructive or destructive. Constructive approach is when the cross-examination of witness is done to highlight or to get certain facts from the witness which can help you. Another is a destructive approach where you can destroy the credibility of the witness, that he is not making a correct statement, he is not a trustworthy. You can adopt both this approach in your cross-examination, depends on the facts of the case. For effective cross-examination, you will have to prepare a case thoroughly. You should aware about the plaintiff's case, in civil matter in plaintiff's case and the defense taken in the written statement. You are required to put a question of which you know the answer. Otherwise, you will be surprised the answer given by a cross-examination. Preparation of that level is required for the cross-examination. You are required to decide whether which witness is required to be cross-examined in detail, which witness is required to be cross-examined in short. There is no straitjacket formula for conducting cross-examination, and each case is having a unique facts and circumstances. Sometimes the lawyers ask a question, it's a follow-up question, you can say, and the witness get a chance to explain his earlier statement. You should avoid that. Mr. Virmani will explain how to cross-examine a witness. So without taking much time of you, we are all here to hear Mr. Virmani on this subject. I have also very little experience of cross-examination as I have practiced in High Court mainly. But in arbitration, I have conducted cross-examination. And in criminal case, especially the cross-examination is very important. But I find that the lawyers prepare the cases for cross-examination in the court. They have no occasion to meet the accused because sometimes he is in jail. Their relatives don't know the entire case. In legal aid matters, when the cases are allotted to the lawyer, I request them to first go and meet the accused and before argument. Have a conversation with him in the jail. We are requesting the jail authorities to provide the place where the lawyer can discuss with his client. Then only they can prepare effective cross-examination. Thank you very much. I welcome Mr. Birmani to address us.
Thank you, my lord, for your enlivening words. It is now my great